As a landlord for over 25 years, I am often asked about managing private rentals. These are some of the most common questions that I answer. If I didn't collect a rent deposit before the tenant moved in, can I get one now? A landlord can collect a rent deposit as long as they ask for it on or before the day that the landlord and the tenant enter into a tenancy agreement. The landlord cannot require something different after the tenancy agreement was made unless it's in accordance with the law or legislative changes. Essentially, this means that the landlord must receive the rent deposit as part of the approval process or before the lease is signed. The rent deposit cannot be more than 1 month's rent or the rent of one rental period, whichever is less. For example, if rent payments are made weekly, the deposit cannot be more than 1 week's rent. If the rent payments are made monthly, the deposit cannot be more than 1 month's rent. The rent deposit must be used for the rent on the last month before the tenancy ends. It cannot be used for anything else, such as to pay for damages, cleaning, or the cost to re-rent the unit. Can I charge a damage deposit if a tenant has a pet? No. In Ontario, damage deposits are not permitted. A landlord cannot collect a damage deposit to pay for damage done to the unit regardless of pets, smoking, or occupants. A landlord can collect a last month's rent deposit, but cannot use that last month's rent deposit to cover damages in a unit. The rent deposit can only be used for the last month's rent before the tenancy ends. If the landlord finds that a tenant has damaged the rental unit or caused damage to the building, the landlord can ask them to pay for those damages or provide the tenant with an N5 for damages. If the tenant does not pay, the landlord can apply to the Landlord-Tenant Board to determine if there are damages and what should be done about them. This form is commonly known as an L2. I don't like the standard lease. Can I make my own lease? A tenancy agreement, also called a lease, is a contract between a landlord and a tenant. In the contract, the tenant agrees to pay rent to live in the rental unit provided by the landlord. The lease also contains other obligations and rules relating to the tenancy for both the landlord and the tenant. If a tenancy agreement is first entered into on or after April 30th of 2018, it must be in writing using a standard lease form developed by the Ministry of Housing, with few exceptions. For most small or private landlords, the standard lease will apply. The standard lease is called Residential Tenancy Agreement Standard Form of Lease and can be found on the Landlord-Tenant Board website. If a landlord and tenant entered into the tenancy agreement before April 30th of 2018, the landlord does not have to replace the existing tenancy agreement with a standard lease form. The landlord can add an addendum to the standard form of lease to include additional rules or regulations, providing those rules and regulations do not contravene the RTA or other laws. For example, a landlord could include a section on smoking or damages as part of their addendum to the standard lease. How often can I raise the rent? Rent can be raised once per year, providing at least 12 months have passed since the first day of the tenancy or the last rent increase. This is any 12 months, not a calendar year. In Ontario, the guideline rent increase amount is set each year based on the Ontario Consumer Price Index, or CPI. The CPI is a measure of inflation calculated monthly by Statistics Canada, using data that reflects economic conditions over the past year. The guideline allowable rent increase applies to most residential accommodations covered by the Residential Tenancies Act, or RTA. It does not apply to rental units in buildings occupied for the first time after November 15th, 2018, social housing units, long-term care units, or commercial property. The rent increase guideline is the maximum most landlords can raise a tenant's rent without the approval of the Landlord-Tenant Board. Rent increases are not automatic or mandatory. Landlords may only raise the rent if they give tenants at least 90 days written notice using the correct form. What happens if my rents do not cover my costs? Can I raise the rent more? This often happens when a landlord purchases a rental property. The current rents may not cover all the costs of operating the property. In a case such as this, the landlord will have to take a loss at the end of the year. A landlord cannot increase the rents above guideline except for in very specific cases. A landlord can apply to the Landlord-Tenant Board to approve a rent increase above the guideline for a few specific reasons, such as the landlord's costs for municipal taxes have increased by an extraordinary amount. The landlord did extraordinary or significant renovations, repairs, replacements, or new additions to the building or to individual units. This type of work is called capital expenditure. The landlord's costs for security services increased, or the landlord began providing security services for the first time. If the landlord applies to the Landlord-Tenant Board for an above guideline increase, they must wait for the order before taking action to collect the requested increase from the tenant. If the landlord has a loss for the year, your accountant can help you best understand how this loss may be used against other income you have. Be aware, the CRA does not often permit multiple years of losses. Again, speak to your accountant for the best advice. Do I have to give my tenants rent receipts? A landlord has to provide a tenant rent receipts if the tenant requests them. The landlord should provide a receipt for rent or any payment or deposit if the tenant asks for them, including payment of rent arrears. The landlord cannot charge for these rent receipts. Landlords also have to give rent receipts to former tenants during the first year after the tenancy ends. My tenant is late with rent. What can I do? If a tenant does not pay the rent on the date it's due, the landlord can give a form called Notice to End a Tenancy Early for Non-Payment of Rent, which is commonly known as an N4. This can be issued the day after the rent was due. The notice, N4, gives the tenant 14 days to pay the rent that's owing or to move out. If the rent is not paid and the tenant does not move, the landlord can apply for the Landlord-Tenant Board that requires a tenant to pay the rent that is owing and or evicts the tenant if they do not make the entire payment by a deadline. An adjudicator will make a determination and an order will be issued to all of the parties. My tenant is not paying rent because they're claiming a maintenance expense. A tenant cannot withhold rent based on perceived maintenance not being done. If a tenant is withholding rent, a landlord should file a notice of termination for non-payment, commonly known as the N4, as soon as possible. If the rent is still not paid by the deadline on the N4, the landlord should file the application to evict and obtain an order for the outstanding rent. This is commonly known as an L1. However, a responsible landlord will also investigate the claim for maintenance by providing a minimum of 24 hours written notice to enter the unit to review any maintenance needs. It is prudent for a landlord to document the findings and share the information with the tenant to ensure nothing is missed and that everyone understands the course of action. If no maintenance concern is identified, this too should be documented and communicated to the tenant. The tenant has up to 1 year to file an application against the landlord, and it could take another 6 to 12 months before a hearing takes place. Maintaining adequate documentation ensures memory and evidence should a tenant attempt to take action against the landlord. My tenant is asking for a rent abatement. What do I have to give them? A landlord is not required to provide a tenant a rent abatement unless ordered to do so by the Landlord-Tenant Board. If a rent abatement is requested by a tenant, a landlord should investigate the concerns that have led to the request. If it's a maintenance issue, the landlord should diligently address the maintenance concern. Always ensure the landlord maintains great documentation in case a tenant files an application against you at some point in the future. My tenant wants half his last month's rent back because he left on the 15th. The tenant is required to give notice to vacate, which is at the end of a rental term or lease period. For example, if the tenant has completed their lease term and the rent is due monthly, the tenant must give 60 days written notice to vacate the unit at the end of the rental period, which is usually at the end of the month. Check your lease to ensure you know when the rent is due and what dates that rent period covers. If the tenant is required to give 60 days written notice and the rental period is from the first of the month to the end of the month, then the tenant is responsible for the full 60 days notice period, regardless of whether or not they choose to vacate early. However, if the landlord has not received the keys prior to the end of the notice period, such as the 15th, the landlord should not expect to take possession of the unit for the purposes of doing work to ready the unit for the next resident without compensating the previous tenant. Once the tenant hands the keys in, they have returned possession of the unit to the landlord. Be careful and seek legal assistance if in doubt. If, however, the landlord is able to rent the unit early, as in prior to the end of the notice period provided by the tenant, then the landlord has an obligation to return the unused portion of the rent to the tenant that vacated. A landlord should not profit or double dip for rent within the same rental period. For example, if the tenant vacates on the 15th and the landlord rents it for the 21st, from the 21st to the end of the month, the landlord needs to return that portion of the rent to the previous tenant. Why can some landlords charge a higher rent increase than the allowable guideline? Ontario has a two-tiered rental housing program. One has a cap on rent increases and the other allows for unlimited rent increases. It's very confusing for tenants. The rent increase guideline applies to residential accommodations occupied November 14th, 2018 or earlier for the first time that building was occupied in its existence, but does not apply to rental units in buildings occupied for the first time after November 15th, 2018, social housing units, long-term care homes, or commercial property. If the landlord owns a rental unit, condo, house, etc., that was occupied for the first time after November 15th, 2018, they can raise the rent by almost any amount after the lease term expires or 12 months lapses. This system creates difficulty for both landlords and tenants, as some tenants are at risk of high rent increases, while other landlords with rental accommodations occupied before November 14, 2018 are faced with very small rent increases that do not cover the cost of increased inflation. It's an unfair system for both landlords and tenants. Alas, it is the system that remains in place as of the making of this video. It's really important for a landlord to know when their unit was built and when it was first occupied. Another example. The unit was built in 1978, but this tenancy started in 2019. Is it rent controlled or unlimited rents? In this case, because the unit, the home, the whatever the residential complex was built prior to November 15th, 2018, regardless of when the tenancy started, the occupancy of that home was prior to November 15th, 2018. Therefore, it's under rent control. It doesn't matter when the lease started, it mattered when that dwelling got occupancy status. What can I do if my tenant won't allow me to enter the rental unit after I gave proper notice? If the landlord has a valid reason, as allowed by the RTA, for entering the rental unit, a tenant cannot refuse to let the landlord into the unit. If the tenant does blockade the door or verbally refuses to allow the landlord into the unit, the landlord can call the police for assistance if there is a concern for the landlord's safety or an escalation in the tenant's behavior. Be aware, the police may not assist in matters relating to landlords and tenants, regardless of your rights as a landlord. If a tenant does not let the landlord in, the landlord can give the tenant a notice of termination, N5, claiming that the tenant is interfering with their lawful rights and the tenant could be evicted. Unfortunately, this is not a timely occurrence or action and could take many months to be resolved. If the matter is urgent, such as a water leak or risk to the building, consider seeking help from local building standards or fire prevention officers, depending on the nature of the issue. Interfering with a landlord's lawful right is an offense under the RTA. What is the difference between an assignment and a sublet of the rental unit? Assigning a rental unit means the tenant moves out of the unit permanently and transfers the tenancy to another person. All of the terms of the original rental agreement stay in place, such as the rent or any services included in that lease agreement. Subletting a unit means the tenant moves out of the unit for a period of time, temporarily, but plans to move back into the unit before the end of the tenancy agreement. For example, a student on a 12-month lease may leave for a 4-month term elsewhere, but returns to the unit for the remaining 4, 6, or 8 months left. The person who moves into the unit during a sublet is known as a subtenant. That person, that subtenant, pays the rent to the original tenant, who pays the rent to the landlord. The original tenant is also responsible for requesting maintenance or requesting any changes to the term of the lease. The subtenant must work with the original tenant, and the original tenant works with the landlord. A tenant must have the landlord's approval to assign or sublet the unit, but the landlord must have a good reason to refuse. My past tenant caused huge damages and left without notice. Can I use the last month's rent to pay for the damages? Alas, no. Last month's rent can only be used for the last month the tenant lived in the rental unit. It cannot be used towards damages, cleaning expense, or painting. However, if the tenant did not give proper notice, the last month's rent can be used for the last month that the tenant should have lived in the rental unit if the rental unit was not rented during that period of time, unless, of course, the Landlord-Tenant Board says otherwise. For example, if the tenant gave you 15 days notice that they were leaving and they legally needed to provide you with 60 days written notice, then you do not need to refund them the last month's rent deposit until you re-rent the unit within that time frame. That does not mean you get to keep the money and just sit on a vacant unit. A landlord must attempt to mitigate the loss to the tenant, and that means trying to re-rent the unit for as soon as possible. If the unit is rented in the same period that is covered by that last month's rent deposit, then the landlord must return the last month's rent or the part of that rent, depending on when the unit was rented, to the previous tenant. How can I evict a tenant? A landlord must have a valid reason to evict a tenant, such as non-payment of rent, improper behavior, impaired safety, or the landlord's personal use of the unit, as some examples. In most situations, before a landlord can apply to the Landlord-Tenant Board to evict a tenant, they must first give the tenant a notice of termination that tells the tenant the reason the landlord wants to evict them. For some termination notices, the landlord must read the instructions carefully and wait a specific number of days to see if the tenant corrects the problem before they can file an application with the Landlord-Tenant Board. The number of days the tenant has to correct the problem is indicated in the notice. If the tenant does not correct the problem and/or does not move out, the landlord can file an application with the Landlord-Tenant Board using the correct form based on which notice the tenant was originally given. In most situations, a hearing will be scheduled within 2 to 6 months. Wait times in 2022 are much longer than normal and could be 6 months or longer before the application is heard. At the hearing, the member listens to the landlord and the tenant and then makes a decision. If an eviction order is issued, it tells the tenant when they must be out of the unit. If they do not move out, then the landlord can file this order with the court enforcement office, commonly known as the sheriff. Only the court enforcement officer can evict a tenant. Can a tenant be evicted in the winter? Yes, a tenant can be evicted anytime an order is made based on the enforceable date shown on that order. Not being able to evict in the winter is a myth. The landlord can file this order with the court enforcement office, commonly known as the sheriff. Only the sheriff can enforce an eviction. How can I collect my money after a landlord-tenant board order? Once you received an order for rent or damages owing, a landlord has a few options to collect the debt, including garnishment of wages if you know where the debtor works. Place a lien on the home if the debtor has purchased property or otherwise owns property. Schedule an examination hearing to obligate the past tenant to attend and answer questions such as where they work, what assets they have, and possibly arrange for a payment plan. File the debt with a collection agency for partial recovery, less the agency's fees. This also gets it registered on the credit bureau. Collecting a debt is not easy, and in many cases, the debt may not ever be collected. This is especially true if the debtor is receiving some kind of social assistance, as this income cannot be garnished. One of the best methods a landlord has to collect, if the place of work is unknown, is to list the debt with a collection agency. With an agency, the debt will be listed on the credit bureau to warn other prospective credit grantors or landlords about the unpaid debt.